All right, we'll jump right into it. And same disclaimer as last time. So again, I'll try to answer your questions as best I can, although Christy is fairly on the mark. And I'm all for drinking games, provided Mutual of Omaha is stocking the bar. I think,
I'll have some water tonight.
yeah. All right, so this is a repeat. I just want to make sure that everyone is aware of the resource, which is oscn.net. If you weren't aware of this, just go to oscn.net and familiarize yourself with the resources. There's AG's opinions, there's statutes, court rules, which y'all probably aren't that interested in, but statutes and case law, it's all available there. So really great resource. And then I cite for you here the Oklahoma Community Association specific law. I call it the Condo Act up here. You won't find that term in the Oklahoma Condo Act. It'll be phrased Unit Ownership Estate Act. And if you've ever looked at your covenants and at the top it says Declaration of Unit Ownership Estate, you just know that you're a condo. That's what they used to call it way back in the 60s and 70s. HOA, don't know if I specifically mentioned this, but HOA is an abbreviation for Homeowners Association. Whether your association is called an HOA, a POA, some other acronym that we might come up with, it's a community association, homeowners association, so we usually say HOA. Oklahoma's law for community associations in the form of a homeowners association is Title 60, starting with Section 851, it goes through Section 857. Not a whole lot of law on it. If you care to go look at it, it basically gives us a framework for creating them, somewhat operating them, but doesn't answer a whole lot of questions for us. And then we have our General Corporation Act. So we talked a little bit about some of the things that we're going to talk about tonight last week, but the purpose of tonight is to go into more depth about certain topics. And we're going to talk about assessments, amendments, enforcement, insurance, and then if we have time and there's questions, about board operation. So the first one that I want to talk about is assessments. And I know it's a common thought that this is the main function of a community association, but it's really not. We talked a little bit last week that one of the things an association can do is provide timely information, a board can think about what goods and services it wants to provide and inform its budget around that. That really is what, in my mind, and I guess this is somewhat debatable, but in my mind that's what a community association's primary function is to determine how are we going to promote community. And it's going to look different for different neighborhoods. If the board's approach and the members' understanding of its association is all it is this dollar monster, well, you will have a form of association. It just may not be promoting the kind of community that we necessarily want to spend time in. With that being said, it is a necessary function of associations to collect money. That's just simply a reality, just like it's a necessary function of various forms of government, municipalities on up to the federal level to collect money. That's what funds the budget. So that in a community association setting is sliced up a few different ways, and I have 4 different ways up here. Again, terminology is not so important, although words do mean things despite what we see on Twitter and hear in the news anymore. It means a lot in community associations because we're interpreting our covenants. We're applying the covenant language. So we have to read that language. If we have defined terms, we have to use those defined terms. And sometimes there's a definition section in the first part of our covenants that will define base assessment or annual assessment or periodic assessment. And that's the annual, monthly, whatever regular dollar amount that the association collects from us to fund operating expenses. How do we pay the lawn guy or gal? How do we pay the light bill, water bill? What do we use to spend on the Halloween trunk or treats festival every year? You know, the the expected expenses of the association. And that's the first one, and I call it annual up there. The next slice is a special assessment. Now, as we move away from the first category, your covenants may not say anything about it. If your covenants don't say anything about assessments or dues, you don't have a mandatory association, you have a neighborhood watch association or something like that. If they provide for one category only, whether they call it annual, periodic, or whatever, you basically have the first category. Condominium associations, almost certainly, and most modern community associations, homeowner associations, are going to have these other categories. And so as we go along from here, we're venturing into areas where it is vitally important that we read and know and understand our covenants, because if we go back to the law slide, if you look in the HOA Act, it's not going to say anything about special assessments for a community association. And we'll talk about special assessments, but it's talking about government, taxes. So we're venturing into area where the words on the filed covenants are very, very important. I have read covenants where they use the term special assessment, but they're not talking about special assessments as I typically understand them. They were talking about some kind of fine or penalty. That's a little unusual to me, but if that's the way they're drafted, that's the way we have to operate, okay? But most of the time, special assessments means some kind of charge or assessment for an unexpected, or sometimes it's tied to a dollar amount, a big expense. Oftentimes it's we have to raise money for an insurance deductible, or we need to raise money to fix the big sinkhole in the middle of the private street. Those are some type of capital improvement or unexpected expense. Oftentimes that's what it's talking about with a special assessment. The next one, specific or individual assessments. Oftentimes these are understood as a fine or a monetary penalty. This is one of those areas where you need to be sure to read your covenants and don't just hear something and take away from here. Monetary penalties or specific assessments are great. They work really well, so let's start doing it. You can get your association and possibly yourself in a lot of trouble if you start tacking on charges that we've just made up, okay? If you're going to fine, if you're going to use money, penalties, monetary penalties as a function or an example of an enforcement technique, you've got to have that in your covenants, okay? Fines are a very influential and effective enforcement technique. If you're looking at amending your covenants, and we'll talk about amending covenants in a second, I'd put that on the category of, to look at least, if not to actually do. And we'll get to the reasons why fines are effective in just a second. But that's another category. And then finally, reserves. I think we talked a little bit, or I may have mentioned reserves last week. I tend to harp on reserves a little bit. A reserve assessment is one either to fund a reserve prospectively, meaning we have this amount that we know we're going to pay in the future, and we have to raise this money as we go. And so in addition to the regular assessments, we're going to adopt a per lot reserve assessment of $2 or whatever it is. And so over time, we're basically building this fund to pay for things that we know wear out. We know streets wear out. We know ponds have to be dredged. We know roofs have to be replaced. That's often the big one. If you're in a condominium development or have ever lived in a condo, water leaks, whether it's plumbing or from the roof, are constant things that you're battling. Okay, and most condo associations around here are just praying for a hailstorm so that they can get a new roof and somehow with those insurance funds fix those water leaks. That's a really common and big deal. Well, those are often addressed with reserve funding. Your covenants may also provide a reserve assessment to make up a reserve fund that hasn't been adequately funded. So again, it just depends on the language. You'd have to look to see whether the board can adopt each one of these assessments if you have it unilaterally, meaning the board can adopt special assessments, or does it take a vote of the membership? And you see it both ways. I draft them both ways. It really just depends on the project, depends on what the owners want, or the developer if I'm drafting it for the developer. So there's not a uniform system. So if you come across the internet, language that says, well, it takes a simple majority to adopt a special assessment, that may or may not be true. Okay, so you just have to look. I'm not going to go over the procedure, just to say that we're probably past the age of handwritten ledgers. If you're still keeping accounting system by handwritten ledger, there's nothing wrong with that. It's just a lot of your customers, if you want to think of them that way, are going to expect you to be able to email, to send electronically. I saw something, it was a meme the other day. It was supposed to be this conversation between two women, and one said, I'm making up the names, Sally, can you fax me such and such? And Jane says, no, I can't. Why not? And she said, because I live in 2018. and it was funny. I still fax. I have a fax number that I use. But all that's to say, your customers, your members are going to expect a certain level of sophistication, let's call it. And so having an accounting system, when I'm standing in front of the judge, I've got to have very clear accounting. And when I'm collecting an account for an association client. And it's not that I can't collect on a handwritten ledger, it just, it speaks a little bit more of we know what we're doing, we have our figures together, we didn't forget to carry a 1 in our hand arithmetic. So let's talk about collections. We talked last week, I probably talked too long about non-judicial remedies and how to be a good neighbor, and all of that is still in effect. Nothing I say today countermands any of that. Those are the things we talked about last week. Those are still the best collection remedies. Avoiding a fight, if you can, is time effective, cost effective, and relationship preserving. And so it's not that you absolutely back down from a fight, because sometimes it's, as much as it depends on you, you can live at peace with others, but sometimes others just won't live at peace with you. And that's the time perhaps you need to enforce things. So let's talk a little bit about collections. When it comes time to collect, it starts with a demand letter. And anytime a third party is collecting debt in a consumer setting, so you buy a couch, you don't pay for it, somebody comes after you, that's a consumer debt. You don't pay your association dues, somebody comes after you in collections, that's a consumer debt. It's very clear under federal law, the 10th Circuit, which is where we fall, that's a consumer debt. All that means is it's subject, that debt collector and your association by extension is subject to the Fair Debt Collections Practices Act. You don't have to know the ins and outs, that's why you hire professionals, but you do need to know the right questions to ask. And one of them, of your debt collection professional, whether it's a manager or a lawyer or your bookkeeper, is, are you FDCPA compliant? And if they say, what? That's not a good indication, okay? You want to make sure that they're FDCPA compliant, because what happens under FDCPA, potentially, if you violate it, if your debt collector violates it, then the debt could get wiped away, and there could be potential civil penalties. Not just for the debt collector, but also for the creditor, okay? So FDCPA is not something that we mess around with. It's very straightforward in terms of the safe harbors or how you comply, but it is something that applies to us all, not just the people who call and say they're going to throw grandma in jail if you don't pay your dues. So,
excuse me, what does the FDCPA stand for?
Fair Debt Collections Practices Act. It's a federal law that was primarily adopted to restrain those people that were calling and saying, if you don't pay this debt, I'm going to throw your grandma in jail. You know, I entertain myself with YouTube videos. One of them is the people that record the IRS tax lien scammers. You know, it's funny because this guy is on the phone saying, you know, and it's always like 4,000 or 5,000, not something so outrageous you couldn't do it, but it's still a little bit of money. You know, they're on their way right now, you need to go to an ATM, and they never put it together. Well, if I leave the house to get your money, how are they going to arrest me at my house? But it's those kinds of people that FDCPA was designed to restrain. You know, lying. One of the things with FDCPA is you can't tell a lie. Well, most of us operate by that moral code anyway. I don't need a statute to tell me not to lie. Except there are things that we do that sometimes look like lies. So for example, if you look at your account statement that you send to a debtor, what does it look like? Does it have principal amount? What are the annual dues? Then does it have costs? So if you filed a lien, there's a $13 filing fee. Okay. Then do you tack on a $50 time fee? Well, you know, I should be compensated for, I'm speaking as a board member or a bookkeeper, I should be compensated for my time. It took me a little while to go down there and file it. So we'll tack on $50. And then you haven't paid on time, so we're going to tack on a $25 late fee. Okay? Well, if our covenants don't allow me to charge $50 for my time, and they don't say anything about a $25 late fee, when you send that to a debt collector, you're trying to collect a debt that does not exist. That's the same as telling a lie under FDCPA. So you want to make sure that if there is a demand on an account, that those are real numbers, right? Otherwise, shoot, why not $50? Why not a $100 late fee? Let's make it $1,000. Yes, ma'am.
Sorry, so is that usually listed in the covenants? I mean,
it has to be listed.
Right, $50 or whatever.
It has to be listed in the covenants. More than likely, I do come across covenants every now and then that will have a $25 late fee. I'm not a big fan on flat dollar amount late fees. Most certainly, if they are a per day penalty, I'll tell you, you can't collect it. And it's not because we have a statute, but we have a case called Sunridge Investors. It was in a landlord-tenant context where the Oklahoma Supreme Court said $5 per day late fee on rent is unenforceable. That's void against public policy. It's a penalty, an unconscionable penalty. And so by implication, I think we're probably going to get that in a HOA context sometime. Usually what you see in your covenants is a penalty interest. Perfectly fine. Oftentimes you'll see an 18% per annum if you don't pay it. I very rarely see covenants that say whether you can compound the interest or not. Most associations compound the interest.
Question.
Yes, ma'am.
If the homeowners association hired an attorney to send out serious demand letters and he had tacked in a $100 penalty, is that legal to tack on to the plan?
It is if the covenants provide that costs of collection are to be added to the account. Yes, sir.
Can you just file liens with all that package put together, and we just sit on houses and wait till they foreclose or sell, and then just rake it in and nobody says anything?
Yeah, you can. So let's talk about another category of fake debt. All right? So the $25 late fee is one that we have to be careful of. Debt that is older than 5 years is also another category of fake debt, and that's because of something called the statute of limitations. So the statute of limitations it's a statute. If you want to look it up in Oklahoma, go to OSCN, type in 12 space OS space 95. And that will take you to the Oklahoma statute of limitations, one of them, the one that we're talking about here. So in Oklahoma, if you have a written contract, the statute of limitations is 5 years. If you have an unwritten contract, just an oral handshake deal, it's 3 years. We have a case in Oklahoma that's from the Court of Civil Appeals where they talk about, well, association debt might be 3 years because it's kind of like an oral contract, but then you've got these file covenants, that's kind of like a written contract. And so they have this conversation, in this opinion about, well, is it 3 years, is it 5 years? And they say, well, that's not before the court, so we won't answer it. And so we have this opinion where they talk about this and they highlight the issue, but they don't resolve it for us. We use a 5-year statute of limitations. I think it's fairly well held or commonly held among attorneys that it's a 5-year statute of limitations. What does that mean? It means that if you're going to collect a debt, it can't be older than 5 years. Now there are certain exceptions. If the debtor reaffirms that debt in writing, if the debtor makes a payment on that debt. So those of our associations that want to take a hard line and respond to debtors' offers to make payments, nope, you pay it all now, all up front, or we're not taking a dime, are pretty foolish because money now is much better than the promise of money later, and plus it reinvigorates the debt in some cases that might be dead. So we're big fans of payment plans. Partly too, and I'll answer a question in just a second, partly too, while I'm talking about payment plans, one of the things that we're looking for debtors is I'm looking for that person who is going to do what they say they're going to do. I won't ask for a show of hands. I'll use myself as an example. I have paid off of old medical statements because I couldn't afford the most recent medical statement. I have sat on bills because, you know what, I didn't really like the way they treated me, so I'm not going to pay this right now. I have run the gamut of why debtors don't pay, okay? I get it. I understand. And people continue to do that. What I'm looking for as a debt collector is I want that person who is a good faith person, who is honest about it. Look, I'm not going to pay this until the president says he's sorry to me. Okay, I understand. May not agree, but let's talk about that. Or I just lost my husband. I'm not paying anything until I do this and this. I get that too. Those kinds of folks don't necessarily need lawsuits. They need somebody to talk to and somebody to work with them. They're tailor-made for payment plans. Okay. Yes, ma'am.
If they are delinquent on their dues and then they send in the current year dues, but don't specify what year, can I apply it to the oldest year to keep it within the 3 to 5 years? It's not specified.
Yes, let's talk about two things. One is the question you asked, and another one that makes me think of this. So this is another reason why having accounting systems like QuickBooks or some kind of accounting software is good, because the software is going to do that for you. It's just going to apply it to the account and have a trailing balance. If someone specifies, so this is kind of the equivalent of me paying off an old medical statement. If I direct on the check or somehow in writing direct that you are to only apply this to the 2018 dues, not the 2015, 16, or 17 dues, and definitely not for any of the attorney's fees you're trying to stick me with. Now the association has to make a choice. They have to make a choice, okay, are we going to take right now money and argue about this other stuff later? Or are we going to send it back and tell them we're not going to accept directed payments? We, as a policy, we don't accept directed payments, okay? It's questionable if they say apply it to 2018 and we go ahead and apply it to the oldest debt. That's possibly not a problem. It is a big problem if they write on the check payment in full, account closed, something that under the law is called an accord and satisfaction. Now, that is a problem area. And in fact, it's such a problem area that under the Uniform Commercial Code, which is a body of law that most states have adopted, Oklahoma has a version of the UCC, there is a section that deals with accord and satisfaction, because this happens all the time. Not necessarily with community associations, but sometimes with big corporations. They get thousands of checks in, and somebody sneaks in an accord of satisfaction, and next thing you know, they say, I don't know, the $15,000 you say I owe? I don't, because you accepted the $1,500 that I sent in as an accord and satisfaction. What the law says is, if you deposit that, you have 90 days to return the check, or a check to them, and tell them, no, even though we may have deposited, we're refunding that, and we're not accepting your offer of settlement. Okay, we have to be careful with that, and usually what we'll do is if we get something like that in, we send it back and, thank you for your attempt to pay. However, there's language on the check that is unacceptable. Send us one without that language, and we'll be happy to apply it to your account. So accord and satisfaction is something that we have to watch out for.
So I can write on my check to my mortgage company, payment in full. And if they don't catch it,
what it does, you can do that.
thought of that, didn't you?
You can do that. More than likely what will happen is within 90 days you'll get the check back, or you'll see a credit back to your account. Even if they don't, what you're doing is setting up a court case, a fight. Attorneys are going to fight about it in court. The way that the law works is if I owe $15,000 and I'm not in any kind of conversation, there's no settlement negotiations, and I just out of the blue send in a $1,500 check and try to do an accord and satisfaction, the court's not going to find that reasonable. The accord and satisfaction has to be reasonable. So if I owe $15,000 and we're in negotiations and y'all are at $8,500 and I'm at $7,500 and I decide, forget this, I'm just going to send them the $7,500 and see what they do, that's probably, and they accept it, that's probably a case where I have an accord and satisfaction. Okay? Yes, ma'am.
Does it have to be something that's disputed first? They can't just...
It has to be, yeah, it has to be in dispute. That's one of the elements. Mm-hmm. Yes, ma'am.
And when you were talking about the fines and different things about the daily fines, if the language in your covenant talks about like different sanctions that the board can do for not payment or violations, and it talks about assessment of fines, like that's specific language, but it doesn't like give amounts, like there's no amounts anywhere in the language.
Mm-hmm.
It's like we can't assess this, but it doesn't give us an amount that we have to. How do you do it to make sure that you're staying within the covenant, you're not going to get in trouble? Like, how do you decide what that fine is? How do you decide, is it implemented monthly, daily?
Yeah. So the thing with any covenant language, including fines, is reasonableness. That's the standard that we're dealing with. Well, what is reasonable? And so one of the things that you're wanting to do with fines, if it says you can assess fines, is also look for rule-making language. If it's not there with the fine authority, it may be in the bylaws or somewhere else. And so you want to follow whatever language you have, whatever procedure is set out in the governing documents for adopting fines. Maybe it doesn't do anything. And so what you want to do is, as a board, demonstrate notice, due process, and fairness. One of the things, if the covenants or bylaws don't require rules to be voted on by the membership, the board can always have the members vote on it. That's one of the best ways to promote reasonableness or create an argument that these are reasonable. This isn't something that was adopted by three or five board members. This was adopted by a majority of the membership. That's a really good way to insulate the board from claims of this is unreasonable. But even if it is just the board, sending out notice, giving a period of time that these fines are going to go into place 30 days from now, giving plenty of lead time and notice and documenting that, I think are good if the covenants don't require it. Most covenants that are going to provide for fines are going to have some mechanism for adopting them. And it's pretty uncommon to have the fine dollar amount specified in the covenants. I'm not a big fan of that because it could change. And so answering the question, well, what should the fine amount be? Well, what is reasonable? I don't think per day fines are reasonable. Per instance fines could be reasonable, but not if we're trying to wire around saying they're per day and saying each instance is every 24-hour period. It's the same thing. So maybe on a 30-day, they need to be set in an amount that we can articulate the reason why they were set in that amount. If boat storage down the street is $35, then a fine of $75 might be reasonable, because we can stand in front of a judge and say, look, if we set the fine at $25, well, it's cheaper for them to just keep parking it in their driveway as opposed to paying the boat storage. Okay, so we want to make it high enough that it is an encouragement, but $1,000 a month for parking a boat in your driveway, that sounds a little unreasonable to me. Maybe.
That's that same, like, if you're saying like $75, would that be regardless of whether the boat was there 2 days or whether it was there the whole 30 days? Like, if it's there for the month, at the end of the month, you assess that fine for that regardless of how many days?
I would say so, yeah.
Thank you.
Yeah.
And then, sorry,
Yes, ma'am.
if you don't have that in your HOA already and you set something like that, but you got people that haven't paid, is that just for anybody going forward, or can you assess that on the old debts that are sitting there as well? Say they've been there for somebody hasn't paid for 3 years, and then 2018 you set that fine. It's 2017, 16, and 15.
And let's be clear, fines are used to enforce use or structural restrictions.
Or percentage.
They're not fined for not paying their assessments.
Okay.
I've never seen that.
Oh, okay.
Yeah, typically the penalty for not paying your assessments is getting a lien filed against your property and penalty interest. Yeah. I would be very hesitant to stand in front of a judge and argue they didn't pay their $250 assessment, therefore they were fined an additional $100.
Well, you said penalty assessment, though.
Penalty interest.
Penalty interest, what if it's a penalty interest? If you just set
we collect-
that 2018, can you go back and collect on previous dues that haven't been paid? Or does that just start that day you set that?
Well, the penalty interest starts from the date of delinquency.
So it can go, you can go back if they've been.
Can you
going-
retroactively apply it to like last year's?
If you have sent them a statement in 2015 that says your dues were $250, and then in 2016 they get a statement that says you owe $250 plus your $250 this year, and then 2017 $250, $250, $250, and then you decide in 2018, well, we're really going to hammer this person, and you go back and apply all that interest. That is a case where it's likely a judge, or possible a judge, will strip all of that out.
So just go forward.
Yeah. Yeah. If you're going to apply penalty interest, you need to do it from the date of delinquency and not send conflicting statements. That's a problem. Let's talk about liens and a couple of things. Liens are very effective in terms of getting people's attention. I know it gets my attention when people file, if someone files a lien against my property. Let's get back to Fair Debt Collections practices and what our covenants say. If your covenants say that liens can be filed but shall be signed by an officer or director, I'm not an officer or director, neither is your manager. And I see that fairly frequently. The last thing we want to do is file something that gives a debtor or their lawyer the argument we filed a false claim against their property. Okay? So we have to make sure our lien practice is pristine. And that's one of the things that I see is managers, attorneys, people who are not authorized under the covenants to sign liens, signing and filing them. Yes, ma'am.
Who are those people who are authorized to sign?
So in those covenants that say liens shall be executed by an officer or director, it's an officer or director of the association. So board member or president, vice president, treasurer, secretary. Most covenants don't specify who the lien has to be signed by, but the lien is it's an evidence of a debt that is owed to the corporation, the association. I'm not a corporate officer, I'm an agent. And if we think in terms of the formality or who signs instruments on behalf of corporations, I couldn't sign a deed on behalf of a corporation unless I'm an officer. But for some reason, there's this idea that attorneys can sign liens and file them, that managers can sign and file them. And it may be that that practice is perfectly fine and can go on for years, but I like to draft contracts and I like to operate by taking away arguments, not creating arguments, okay? So that's one issue that I see with liens. Yes, ma'am?
Liens can't be filed until there's a demand letter, right?
No, there's nothing that says you have to send a demand letter other than good practice, perhaps manners. So oftentimes there will be one or more requests that the person pay. Oftentimes what they get is multiple notices. They get notice when they purchase the property, whether they read the covenants or not by law, because we talked about constructive notice. Then they get an invoice from the association. Oftentimes then what they'll get from the association or the manager is a, whoops, we missed your payment letter. Thanks for being a good neighbor and join the rest of us who paid our dues, kind of thing. Then the next one is often a more gritty, pointed, you've got so many days to pay, otherwise a lien will be filed or it's handed over to collections or whatever. Usually there's several notices. Now it doesn't mean that the association couldn't just send out an invoice and the next thing you know you get a lien. That certainly communicates something, but I don't recommend that kind of practice. The lien is evidence of a debt. It is not the debt, okay? So filing a lien does nothing to do in terms of extending the statute of limitations, all right? So I want that to sink in, that if you've got debt that is nearing its statute of limitations, filing a lien doesn't do anything. The only thing that protects it is filing a lawsuit, okay? You can foreclose liens. We'll get to foreclosure here in a second. Let's talk about a couple of misconceptions. You don't have to foreclose on an association lien within 1 year of filing. That's called a mechanics, materialmen's, and laborer's lien, sometimes called an MML. If I do work on your roof, you don't pay me, I have under statute the possibility of filing an MML. HOA lien is not a mechanics lien, okay? Sometimes you'll hear, well, you got to foreclose within a year or it's gone. Not true. One of the things that I see is, and I'm sure the county clerks love this, is associations filing a lien every single year. You can do that, but if you think about it, a lien is actually, the amount that you state on the lien is invalid the next day. If you state a face amount of $250 owed now plus interest, well, the next day there's going to be more interest, all right? You don't have to file a lien every day. You don't have to file it every month or even every year. That's where this continuing lien language, all you got to say is, at the present time, this person owes this amount plus all future accruing dues, costs, unpaid dues, costs, interest, and attorney's fees. So we just publish to the world, all right, at this snapshot in time, this is how much they owe. Moving forward, we're going to capture the rest of it. We already talked about who signs. Let's talk about small claims collections. And in Oklahoma, you don't have to hire a lawyer to go to small claims. In some states, you cannot hire a lawyer to go to small claims. In Oklahoma, you have a choice. You can go yourself, your manager can go, or you can hire a lawyer. And it really just depends on economics. If you have someone on the board or if your manager is experienced with going to small claims, it's certainly more cost effective not to hire a lawyer. But if the other side hires a lawyer, you're going to be at a disadvantage. Small claims now is any collections case under $10,000. And that, when we're talking small claims in community association setting, that's pretty much all we're talking about is a collections case. You can't get injunctive relief in small claims court. And so you can't file a small claims affidavit, have a trial, and have the judge order the person to move the boat out of their driveway. Can't get that relief in small claims, okay? But you can collect any amount under $10,000. The problem with small claims court, if you hire a lawyer under law and the other person shows up and doesn't contest the action, you're going to be limited to a 10% attorney's fee. So let's walk through that a second. If your association sues for $750, we'll use the $250 a year dues. $750, you go to court, debtor shows up, says, Judge, I know I owe it, I didn't like the president, so I didn't pay it. The judge is going to say, judgment for plaintiff for $750. You're going to get your filing fee of $45 or so, $58. You'll get your service of process fee because we have to hire a process server to serve the defendant. That's going to be about $65. And you're going to get a $75 attorney's fee, which is 10% of the principal amount. The law says in that instance where the claim is undisputed, then you get the claim, 100% of your costs, and a 10% attorney fee. It is going to cost you substantially more than $75 for an attorney to go to court with you. So the board has to evaluate that. Are we willing to live with a 10% attorney's fee in order to get our $75? Once you get a judgment, whether it's in small claims court, district court, or wherever, you still have to collect it. Maybe once or twice, I've had a debtor get hit with a judgment and they open up their wallet right there and pay it. But it's only been once or twice. Usually you have to collect it. Judge isn't going to make them pay, hold them there by, sheriff's deputy until they break out their checkbook. It doesn't work that way. It is entirely possible in collections your association pays a lot of money in attorney's fees and court costs and you don't collect a dime. That is a reality of collections. And so, we can try our best to forecast whether you're going to win and get your money back, but any lawyer that tells you, oh yeah, you're going to win and you'll get your money back, you need to fire them and hire a different lawyer because that one's lying. I mean, if I could do that, I would be in Vegas and not practicing law. I don't know. Until we walk that road, I can't tell you whether this debtor is going to bring counterclaims against the board. There are lawyers and people out there that think the best defense to paying a legitimate debt is to try to scratch the eyes out of anybody that gets in front of them. It's not legitimate, but it's sometimes effective. And sometimes it will convince boards to, forget this, we'll just move on. So, yes ma'am.
After you get a judgment in that small claims, and then it's good for 5 years, right? And then you can renew the judgment.
Yes.
Can we still collect on that because there's that 5-year statute of limitations?
Okay, so as it turns out, judgments in Oklahoma are good for 5 years. That's different than a statute of limitations. But the language that you used, renew the judgment, that is right. That's a different statute though.
Okay.
Once you get a judgment, if you have not collected that judgment, you have to renew the judgment, and there's specific things that you do to renew it. You file a renewal or you get a garnishment issued. So most of the time you have collected, if you're going to collect, or you file your renewal or you have gone through the garnishment process. Yes, sir.
The lawyer fees collected immediately after the judgment, or is it only when the person pays?
The attorney's fees are you talking about whether the HOA pays the lawyer?
Yeah.
It depends on what the association's agreement with the lawyer is. So if they're under an hourly contract, then that lawyer is going to send their bill on a monthly basis and the association pays it. And part of the goal is to collect those attorney's fees at some point from the debtor. If you're on a contingency fee agreement, and there are some debt collectors that work on contingency fee, then that lawyer doesn't get paid until they actually collect something. Let's talk about foreclosures, okay? I'm going to talk about both of these in terms of whether the association's the plaintiff or defendant. Most commonly, your association is going to be named in a foreclosure because the debtor quit paying their mortgage and the mortgage company is capturing everybody in the foreclosure. That's just part of the process. It doesn't mean someone in the association did something wrong. It doesn't mean the lender is looking to your association to pay their attorney's fees or even pay the mortgage or anything like that. It's simply a title cleaning process, okay? So if we talked about MMLs, mechanics liens, a moment ago. If I had done work on somebody's roof, I file a mechanics lien, and then they quit paying their mortgage, the lender's going to sue me. Not because I did anything wrong with the roof, it's because they need to clear that lien in order to get to where they can sell that property free and clear of all the liens. That's what the foreclosure process does. Same thing with the association. It's often a good thing. It's often a shortcut to getting a judgment and a possibility of getting some money out of the sheriff's sale. That doesn't happen a whole lot, but it's happening a whole lot more now. It didn't happen between 2007 and 2010 because everybody was just walking away from their houses, and the foreclosures, the houses were underwater. There was no equity. But if a property, say, its fair market value is $100,000, the lender is owed $20,000, property sells for $70,000, the association is likely going to get paid. Okay, so you can in those cases try to get a sense of, all right, is the association going to get some money out of this? All right, different analysis than small claims debtors, because we're not necessarily looking at the debtor's ability to pay the judgment. We're looking at the property, and that's a little more ascertainable. Okay.
Where does the association stand in the hierarchy of debtors?
They stand under the feet of the lenders under most cases. In 18 years, I have found, I had one case where the association had priority over the lender. It was a case in Tulsa, and everybody, the lender's lawyer, me, we were all just shocked. And the lender paid the association's claim in a heartbeat. But almost in every single case, the association is junior to the lender. So the way this typically works is the association gets sued. You'll receive a petition and a summons. Process server will come to your house, or they'll serve the registered agent of the association. At that point, you have 20 days to enter an appearance or file an answer. And the entry of appearance is just a document that says, hey, we're here, we acknowledge that we were served, and we're going to answer. The answer is the answer. It's the responding pleading to the petition. And it says, we agree, we disagree, we claim, all of this stuff. Okay? It's not impossible for a lay person to do that. Oftentimes you'll see debtors, they're called pro se, meaning they represent themselves, go through the judicial process, but it does take a certain amount of time, skill in order to do it properly. There's lawyers that go through law school and don't do it properly. So it can be done. I don't want to sound self-serving that, oh, if you get served with a petition summons, you have to hire a lawyer. You don't necessarily have to, but it's kind of like asking me to help you with your math homework. I could potentially do it, but it's going to be terrible. So a cross-claim is where the defendant or where the association is a defendant in the lawsuit, and that's what you're wanting to file as a cross-claim. Cross-claim is the pleading that says, we don't contest priority, the lender has priority, but we do have a claim against this debtor, and we do have a claim against this property. That's what gets the association in the running to get paid at sheriff's sale. So if you get to sheriff's sale, there is a sale, there is money left over. At that point, the association can make a claim for a distribution of that. All right? You don't have to go to court and argue the case typically. Oftentimes what happens in these cases is I'll file an entry of appearance and contact the plaintiff's lawyer, tell them, just send me the journal entry of judgment when you're ready, and we will have our journal entry of judgment, the same kind of judgment that we would get if we had sued in small claims court or district court. Okay? So we usually look at foreclosures as a good thing. Sometimes I'll hear from associations or managers, well, we're not going to collect anything, so we just throw them in the trash. Okay, you can take that tack if you want. I think it's somewhat improvident, but you can do that. And then the question, will the association see any money? Again, I can't answer that. I will say this, if the debtor files for bankruptcy, you are not going to collect that debt from that person, okay? At that point, you can only collect the debt from the property. And if you have property that is underwater, if there's tax liens, if the mortgage is $100,000 owed and the property is worth $80,000, your debt's gone, okay? Don't pay an attorney, don't spend any time, it's gone. If the person doesn't file for bankruptcy, if they're trying to stay in the home, even if they don't stay in the home but they have a job and they're not moving out of state or out of town, those are the cases where typically the association will proceed and the person could make good on the debt, right? We talked about bankruptcy. The one thing that I want to point out in bankruptcy, when a person files for bankruptcy, there's something called the automatic stay. Bankruptcy is the last statutory vestige of mercy in our system. Okay? You heard about throwing yourself to the mercy of the court. That does exist, but that's up to the judge's discretion. It is built into bankruptcy mercy. That's what it's for. I can run up debt, and if I meet the letter of the law, I can discharge it. That's what bankruptcy does. Okay? In a condominium setting, if you have a lien filed, that debt is not going to be discharged against the property. Probably it's the same answer in a homeowner association setting. It's not going anywhere. It will be discharged against the individual. I can't follow him from state to state and collect it from him, but I will have my teeth in the property. The automatic stay it's likened to this iron curtain that falls when a person files for bankruptcy, and it stops all collection activity. No more calls, no more demand letters. We absolutely don't go online and post on Nextdoor or Facebook, well, I guess we're not going to collect against Matt now that he filed for bankruptcy. That is one of the worst things. But I get it. I get frustration. I get frustrated too. I just don't go to Nextdoor or Facebook and announce it. Because what happens is you have to stand in front of a bankruptcy judge and answer why you violated the automatic stay, and they take that very, very seriously. So automatic stay, absolutely hands off. I would say if the association wants to explore pursuing debt in bankruptcy, hire a lawyer or somebody that is familiar with the bankruptcy code. Not do that yourself.
How would HOA board know that? Only if we filed a lien? I mean, if they're paying their dues, and how would we know they filed bankruptcy?
Most often, the debtor will include the association in its creditors matrix, meaning anybody that the debtor owes money to, they're going to include them on the creditors matrix. Problem is, automatic stay applies to everyone, not just people who have actual notice of the bankruptcy.
That's what I was getting at. Like, if you didn't know and you sent them a notice.
It's entirely weighted for the debtor. I mean, that's the purpose of bankruptcy, is to give them a pause, a moment of relief from creditors. So, the law has to pick winners and losers, and when it comes to the bankruptcy stay, the winner is the debtor. Yes, ma'am.
Isn't there something in Oklahoma, if they continue to stay in the house and don't become bankrupt, they eventually have to pay those old dues? Or was not?
If they reaffirm the debt personally, then yeah, it will stick to them.
I mean, just because they stayed in the house, that doesn't mean that they have to eventually pay. They have to start paying from dating bankruptcy forward, right?
Yes, so post-petition dues, just like the post-petition light bill, all of those are outside of bankruptcy. So the pre-petition dues, if they stay in the house, or if the association has a lien against the house and they abandon it, then the house serves as security for that pre-petition debt.
Okay, so you don't necessarily lose it if you have a lien against the house before they bankrupt.
That's right. You would lose it if there's insufficient equity to pay all the creditors that have security in the house.
But if they're staying in the house, then you don't have to worry about their rental, right?
If they stay in the house and if they're doing a Chapter 7 and they reaffirm the house, then yes, the association is likely to eventually get paid. If it's a Chapter 11 or reorganization, then there's going to be a plan in place and the association will get paid according to that plan. Yes, sir.
Typically, how long does the process of bankruptcy take? What's the time span?
Take a drink, Christy. It depends. It depends on if it's a... it depends on if it's a Chapter 7 or a reorganization. It depends on if there are creditors that object to the plan. I'm not going to be able to give you a typical time frame, other than Chapter 7s are typically fairly short. I would say maybe 6 months. When you file for a Chapter 7, very quickly there's going to be a creditor's hearing. It's called a 341 hearing, and there's a period of time where creditors can file objections. If the debtor, say in a Chapter 7, a debtor is claiming the house is exempt from foreclosure because of homestead, and that the association can't collect against the house, then that's a bankruptcy. If the association objects to that, is going to get prolonged because you would have a hearing, and the association would have an opportunity to convince the bankruptcy judge that no, this isn't exempt. Homestead doesn't protect, just like homestead doesn't protect against foreclosing on a mortgage. Okay, and that is the law in Oklahoma. If you look at Title 60, Section 852, what it says is the association may file a lien, and it may be foreclosed in like manner as a mortgage. Okay, so when you get someone that says, well, you can file a lien against my property, but you can't foreclose on it, wrong. That's not what the statute says. Okay. All right, I need to move along. I talked about collections. So I've got 4 pictures. Each of them are real. Not.
That's not my house, is it?
No, it's your neighbor's. This was a good story. So there were 2 neighbors in, I believe it was Nevada. And the guy who has the conspicuously configured louvers that look like a middle finger built this house. The neighbor sued him for blocking the view of the mountain, and then these louvers appeared, which looks like he's flipping them off. It's funny. Sometimes our neighbors have parking lots next door.
What do you do about that?
We're getting to that.
Okay.
You can find them, right?
This is one of the first covenant enforcement cases that I litigated. This was all the yard art. It's not junk. It was the lady's artistic expression. The lady, by the way, later was on that America's Most Wanted show. She was going through a divorce. She kidnapped her kids, and she completely destroyed the house, ripped up the baseboards, pulled out the toilets. She was really interesting to talk to. She was a lot of fun. I will say this: she was a lot of fun to talk to. Didn't strike you as crazy. Very personable. She tried to hand me her kid one time in court. She would always come to court with her kid. She was pro se. And she tried to hand me her kid to take him to the bathroom during this court hearing, and like, that's not anywhere near going to happen. She was very entertaining. All right, so what do we do if our neighbor has a parking lot or has the yard art, parks a boat in the driveway? So it always starts with a demand letter, and it needs to start with a demand letter from the association. Once again, I'm assuming we have done all of the other stuff that we talked about last week and tried to avoid getting to the demand letter stage. If we can prevail upon this person to do what they should do, whatever that is in the given circumstances, then do it. But if that doesn't work, then we go to a demand letter. Demand letter needs to identify the owner of the property, the chapter and verse of the covenants that they're not following, give them the specific thing that they need to do in order to make it right, and then give them a time frame on within which to do it, and then the consequence. What happens if you don't? All right? You've given them all the information they need to make a decision. Am I going to do it or am I not? And if they don't, the board needs to move forward with its enforcement. I put penalties on here almost because it's funny. You know, almost every set of covenants will say if a person doesn't pay their dues or if they're in violation, then the association can take away their vote. Throw me in the briar patch, right? You know, the person that's doing this doesn't come to your meetings anyway. They could not care less. You know, that's not it's not an enforcement. Now the next one, no common area use, could go from who cares, so I'm not going to walk the trails, or I'm not going to use the common area that is a drainage pond. Not a problem. Becomes a big problem if the common area is a swimming pool and we limit it with card key access. You collect a lot of dues in May or April and get a lot of covenant compliance. So think in terms of, all right, is there something within the covenants that we can do? Turning off, if you're in a condominium, I get this occasionally, turning off their access to the gate to where they cannot access the property. You can't do that. You can't turn off their utilities. Those are going to get the association in trouble. The closest you can get, so there was a condominium that was gated, and the way it was designed, you could get to your unit through you could park on the street. The way it was set up, it was like this. So if this is the public street, and it came, so there's the gate here. They had a pedestrian door there. What they did was they could turn off the gate access to where you didn't have a punch code and you didn't have your clicker, but they still had access here, and they could actually park on the street and be closer to their unit, potentially. They're right there. And so that association made the decision that they were going to do that. Didn't have to litigate it. It's very, very effective. I traded emails with a guy today in a private community where he used the language, he did not want to, he was disputing the payment of his dues, and he was contesting that the association should turn off his clicker because he would have to stick his arm out and use the punch pad. And the language he used, he was scared of these roving bands of people that are apparently terrorizing his neighborhood. And I was like, you live in Edmond in a gated community. I mean, I think you'll be just fine for the half a second it takes to punch your code and enter your neighborhood. He's just looking for an excuse. So for me, that's probably as close to the line, maybe over that I would ever get. Turning off pool keys, yep, that's effective. We talked about monetary fines. What I want to say about fines again is it has to be really clear. This is a notice issue, that your covenants have to give me fair notice that I'm going to get charged a monetary penalty based on some system, hopefully with a system of due process, meaning if I feel like I'm being unfairly singled out, if I feel like you have the facts wrong, I need some mechanism to where I can go contest this. And that's called due process, okay? It needs to have some language in there about due process. If you're going to file a lien based on a fine, your covenants have to specify it. The fact that you have lien language over here that's tied to assessments, and you have a sentence over here that says the association may adopt monetary penalties, what is it that connects those? Again, we don't want to give people the opportunity to claim, you wrongfully filed a lien against my property, because there are significant statutory penalties plus attorney's fees for slandering someone's title, right? And it may be that if we don't have the language in there that we need, then we need to amend our covenants or get better language in there. The language in your general enforcement that says the association and any owner may bring an action at law or in equity for injunctive relief or damages, that's not fine language. That is very general, very age-old. You can sue them for an injunction, you can sue them for monetary damages, but it's not a fine system, okay? So we can't use that. Yes, ma'am.
So we're talking monetary fines, that's like parking your camper in the driveway or those kind of covenant violations?
Yes, leaving my trash cans out.
Yeah. So you're saying listing in the covenants, is that, I can't remember if you said, do we need a specific dollar amount on that listed in the covenants?
Not necessarily. You can. Ideally, what a fine system is going to say is you're going to use language that's similar to assessments. Specific assessment. This is a specific assessment. This is an individual assessment. And it's going to say the board may adopt a specific assessment schedule, or the members may adopt an assessment schedule. It's going to have some framework for how that's adopted, published, and then implemented. Okay? It's possible that you could just have covenant language that says the board may enforce monetary penalties, but that's pretty light. So the reason monetary penalties are so such a good enforcement remedy is because people understand money. If you tell me I'm going to take $100 you're going to take $100 out of my pocket, I get that. I understand that. If you tell me, well, I'm going to sue you and get a mandatory injunction against you. Okay, I think I know what that means, but it doesn't sound real, and I'm not going to appreciate it as much as you taking $100 out of my pocket. I get that. So there is a realization aspect of it. There's also just the function of the American judicial system, the civil system. It's money. If you hit me with your car out there, I don't get a new leg, I get money, right? If you destroy my truck, I don't get a new truck from you, I get money. That is how our legal system is set up. It's not perfect, but it's an attempt to fairly compensate people for their damages, and the best way we can come up with is money, for most cases. So there's the benefit of that. The judge who is evaluating this case may not have ever lived in a neighborhood that has a community association. They may never have paid dues. They may not feel as strongly. They definitely don't feel as strongly about your neighborhood as you do. They may not even like homeowners associations. And so asking them to issue an injunction to remove this boat, it may really grate on them. Now, judges are supposed to have, if you watch the Kavanaugh hearings, you heard over and over again, they're not supposed to violate this judicial detachment, or this judicial independence was the phrase that he kept using. And so hopefully the judge that we're in front of doesn't insert his or her personal feelings, but I'll tell you, it is much harder to get a mandatory injunction out of a judge than it is a dollar amount. Okay? And that's the thing, is with a dollar amount, we may be asking for $1,000 and the judge says, that doesn't sound reasonable, but $500 sounds reasonable. That's a win. You still get some money. With an injunction, you either get the injunction or you don't. Okay? Now, we still file a lot of lawsuits for mandatory injunction relief. and we'll talk about different kinds of injunctions in a second, but what we're trying to do is convert a typically more expensive lawsuit for an injunction to one that is packaged in a way that the judge understands. Judge, the question here isn't whether the association can fine or not. The only question here is whether the fine amount is reasonable. That is what we're trying to get the judge on our page. It's reasonableness. Okay? Yes, sir.
When we were speaking of dues, that goes to the homeowner, I understand. We go to fines, and all of a sudden we have 15-20% of renters, leasers in the neighborhood. Does that fine go to them? How is it assessed, or does it go back to the HOA fee that the owner of the property would have?
The covenants are enforceable against the owner, and that's another reason, I'm glad you asked that question, that's another reason why fines are effective, particularly if we're having problems with tenants. Because unless it's a family member, the landlord is in the renting business for a profit motive, either to cover their mortgage or to make money or something. And most landlords won't tolerate a tenant for long that eats into their profit margin. So if we're having a problem with a tenant, a fine system is pretty good. Now, you can't adopt a fine system that only applies to tenants. That's unenforceable. But it is effective. Yes, sir.
So the family misses a big trash day. They're not going to pick it back up. So we pick up their trash and charge them for it. They're not going to pay it. Now they want to add on to their house, and they give their plan to the design review committee. We turn that back to them until you get your account settled that we're not going to look at your plan.
That is a really interesting fact pattern, and I don't know if I've ever thought about that before. Can you refuse approval on an architectural addition because they're otherwise in violation of the covenants?
Right.
Two shots.
Yeah. That's an interesting one, and my gut reaction is not unless you have really specific language in the architectural committee oversight clause that says, and I don't know if I've ever read that. In fact, I don't even know if my covenants. I need to let me make a note here for. Yeah, you should get a door prize for that, because I'll probably go modify my covenants based on that question.
I would recommend you do that.
But I'll have to think about it, because I'll have to think about that. But the answer is more than likely no. You could not refuse my sunroom add-on because I haven't paid my dues. Where I do see this, and I'm answering a question you didn't ask, is whether a person can serve on the board when they haven't paid their dues, or if they're in violation of the covenants. It is common to see bylaws or covenants that provide, and if yours don't, they really should. We could probably debate whether I get my sunroom approval from the ARC despite my other covenant violation. See, this is the thing that dorky real estate lawyers, will sit around beers and debate about. But I think it depends on are we talking apples and apples? Did I build a sunroom without ARC approval, and now I have submitted a plan for whatever reason for a greenhouse? I can see an ARC being justified saying, we're not going to approve this because you have this. I can definitely see that. It's a different situation where you don't get your sunroom because you're parking your boat in the driveway. I could see a court making a big distinction between those two fact patterns.
Yeah, I see that now.
Yes, ma'am.
So one of our houses is built on a slope, And because of the drainage, all the debris and everything runs across into the sidewalk. And the homeowner says that they're making an attempt to clean the sidewalk, but stuff is building up, and I've had people report to me that they have fallen there. Whose problem is that?
Is the street public or private?
Private.
It's probably a combination. It's probably an association issue and then the adjoining neighbors issue. If it was a public street, then the association probably wouldn't be involved at all. To the extent the association's property is being affected, then it is an association problem. If it's just, affecting the neighbors, then it's their problem.
So does the association have to do something like clean the sidewalk or install some kind of drainage system on somebody else's property?
No, it would be up to that individual to address it. And it really depends on, are we talking about natural occurring erosion? Are we talking about this person installed a drainage system that focuses all the surface and roof water down to one area?
It's a natural erosion thing. The water just washes down the hill and then across the sidewalk. And there's like mud and leaves and grass clippings.
Yeah, there are instances where, we have to tell people, if you stand in the rain, you get wet and you don't have a legal remedy and someone's not at fault, it's a natural occurring thing and you can't be surprised that it happens. The fact that water runs downhill, that sometimes it washes leaves, it's no surprise. That is just part of living. But where someone has scalped their yard and not put up erosion control and now we have red mud all over the neighbor's driveway or our private streets, that is not naturally occurring. That is a foreseeable thing and they should have put up erosion control measures. You don't usually see that with individual owners. You mostly see that with builders on bare lots or developers. So it really depends on what the circumstances are. But even if it's just a neighbor-to-neighbor issue, the association can take the lead and help them resolve it.
It's not neighbor to neighbor. It's fully in front of their yard, and people fall when they use the sidewalk. So just on them to wait until they get sued.
Well, I guess it depends on who has the maintenance responsibility for the sidewalk. Was the sidewalk installed properly? If people are falling because the sidewalk is wet because it rained, then it really depends on a number of facts. Yeah.
It's because there's like 2 inches of mud there on top of the sidewalk.
Yeah. Again, if it was a naturally occurring event that created mud, then if you had a 100-year flood versus a 10-year flood, and everything was built to spec, and as a result of a larger flood, we now have mud. Sorry, that's just what happens sometimes. Again, if I've scalped my yard or if I've put in a drainage system and now I have focused surface water and it's creating issues, then that would be on the person that has created that condition. Okay, so let's talk about injunctions and declaratory actions. The typical remedy for enforcing covenants is an injunction. There's 2 types, prohibitory and mandatory. And so a mandatory injunction asks the court to make a person do something. Judge, I want you to make this person move this trailer, this boat out of their driveway because we have covenants that say no boats or trailers shall be visible from the street, right? That's a kind of a bread and butter covenant language and injunction lawsuit. The obligation there is to convince the judge that the covenants are real, they're enforceable, they were on file when this person took title to their property, there's no ambiguity, there's no contradiction in the covenants, such as there's paragraph, another paragraph that says boats may be parked in the driveway while fully visible. That's not going to happen, but occasionally what we get are contradictory parking restrictions. Sometimes covenants are drafted so that you have parking restriction that says passenger vehicles, boats, trailers may be parked in the driveway when in use. How do you use a boat in a driveway is probably a question for the court to answer. Sometimes we have ambiguities in drafting and they don't make sense, and that creates opportunities for people to take advantage or have a good faith dispute. If we have a good faith dispute about covenant language, the very best way to resolve that is to amend that language and make it clear. We're going to talk about amendments in our time here in a second. If we can't amend the covenants, if we need a court to decide, there is something called a declaratory action or declaratory judgment. We can't just rush to court if the board says, hey, we have a question about how these covenants read. There has to be a legitimate, an actual controversy, okay? So the board sends a demand letter to an individual says, covenants don't apply to me. It is possible in that instance to file a declaratory action, and often what we'll do is we will bring an action that has a number of causes of action. One, declaratory action. Judge, there's a good faith dispute whether these covenants apply, whether they're still valid because they've been on file for 50 years. So we need that resolved. Number two, to the extent the covenants are enforceable, then we want a mandatory injunction to make Matt move his boat. Okay, that's kind of a common pairing of causes of action. Let's talk about attorney's fees in covenant enforcement cases. There is an opportunity to recover attorney's fees. Forget the 10% under the Small Claims Act. That doesn't apply in district court. And oftentimes, if you are the prevailing party, whether you're the association or the defendant, a court will award attorney's fees. There's nothing that says you're going to sue and win and get all of your money back. It's possible that you could sue and win and not get all of your money back. There are some judges that, because of the facts of the case, they may decide that these parties should pay their own attorney's fees. There is an appeal process. You could appeal that and spend another $3,000–4,000 on your appeal and see if you can get that overturned. The realm of litigation is very broad, even if we're just talking about suing to enforce covenants. And so this is a very high-level look. It's part of the reason why I spent so much time talking about resolving issues, if you can, before you go to court. Because these kinds of cases, once you're in district court, not small claims, those can be expensive too, but whenever you're suing in district court, you're talking thousands and thousands, if not 10 or hundreds of thousands of dollars. Association claims typically don't get to $100,000, but they certainly can. Okay, you get a hold of a defendant who countersues against the individual board members and the association can really be destructive to a neighborhood. So there shouldn't be a rush to go into litigation. It should be calculated. Should be done with the best evidence possible, and sometimes the best business judgment is to avoid litigation. Other times the best business judgment and the only remedy that, or the only option that circumstances give you is to go into court. But it certainly shouldn't be undertaken lightly. Okay, I'm going to move on to amendments because of our time. All right, I want you to read this next slide and process the language. Okay, this is one of those instances, you've seen this before. Don't spoil it. Don't spoil the joke. All right, you ready? This is one of those instances where, language is very important. I did not make this up. I have copied this verbatim, even the punctuation. This is an Oklahoma County association or set of covenants. They do have an association. So this language, whenever you get into underlining, I'm not sure what the single quotes around running means. There's no definition section in these covenants, so there's nothing outside of this paragraph 9 that tells us what running, it's not even this, it's just this. I don't know what's going on with the open parenthetical that never closes. You can read to the very last page and never get its closing parentheses. We won't go into the various interpretations of this. Some horribly un-PC, some of them perfectly logical given the context. Does anybody have any idea what this is trying to do?
No.
Yes, ma'am.
Like for duck hunting or something,
Yeah.
you can't be in your boat and shooting from your boat unless you have a handicap.
Yeah, well, no, not a handicap. You're exactly right up until the handicap part. It's not talking about, the cripple is not talking about a person. It's talking about the duck. Oh. It's a common, a cripple is a wounded duck or a wounded bird, and it's unsportsmanlike to shoot. You know, you can't just pop up and shoot the ducks when they're on the water. They have to be in flight. And unless an animal is wounded, then you can put them out of their misery. You can shoot a cripple, a wounded duck on the water. But even knowing that, and this is a sports community, can I be moving in a boat forward? Can I be in a boat moving backward?
And shoot.
And shoot? You know, what is the deal going on with the motion, and when can the motor be on? It's horrible.
If you turn the key off and it's still in the forward motion.
Yeah. So this is the kind of covenant language that people can get mired in, and we can fight about and spend a lot of money on attorneys, or we can simply just amend it. So one of the reasons why you would amend is if you're stuck with language like that, get rid of it. Okay, we talked about declaratory actions. If there's covenant language that doesn't work anymore, if it's obsolete, it's very common. Remember in part 1 where we talked about the life cycle of a neighborhood? At some point, the developer is going to move on. They're going to sell all of their lots. Well, there's going to be a lot of language left in the covenants that applies to the developer that you don't need anymore. You don't necessarily need to amend it out, but at some point, the neighbors or the owners may want to remove it. Okay? It may be that the architectural committee clause says architectural committee shall consist of Matt, so-and-so, and somebody else, and that's it. That the covenants don't provide a mechanism for turnover. It should have a mechanism, but maybe it doesn't. Well, the time to find out that your architectural committee is not duly organized is not after you file the lawsuit to enforce architectural committee approval. Hopefully your lawyer has asked the question before then, because that's way too late. It is not true just because you have an ARC clause means your current ARC is the duly organized ARC. We have to connect the dots. This is kind of similar to, look, just because you have lien language over here and you have fine language over here, it doesn't mean you can necessarily fine. We have to connect the dots. And if the dots don't connect, we can make them connect by amending the covenants. Okay? All of these slides are, I think you said y'all email them, right, to everybody?
I believe that we can.
Okay. You probably need them from me.
I think if we have one,
It'd be helpful if I did that. So I will do that, and that way she can get them to you guys.
Matt,
Yes.
will the video also be coming our way, or?
No, the video actually is something that me and Craig are working on. The idea is to put online resources and online learning, kind of this, except packaged in different modules and classes. I don't know who is working more slowly on it. I think it's me. I'm pretty sure it's me. But the idea is to have that available at some point in the future. I think it'll be, at least as of now, there is no other resource like that available out there, which is one of the reasons why we wanted to do it, and we like working together. So So for time purposes, I'm going to give you the nuts and bolts of amendments, okay? So with an amendment project, once you've decided we got to amend for whatever reason, for whatever language, maybe you have a set of 6 covenants. It's not uncommon for older editions where you've got 6 different plats. Developer files 6 different sets of covenants. Well, at some point, you may want to squash all of them together and amend them, okay? That's called a consolidation and amendment project. We do a lot of those. That's a common thing. Therefore, at the end of the project, you have one set of covenants. It's pretty handy. Remember last time we were talking about consumers are looking for some level of professionalism, and we can do that with our covenants. So we may want to consolidate them all together. So how do you do that? The first thing to determine is this project even doable? And in answering that, you need to look at what percentage of people do we have to have vote for this project, and what kind of vote are we talking about? It may not necessarily be the kind of vote that you have to elect directors. It may not be a corporate vote. It may be what we call a real estate vote. And if it's a real estate vote, which almost all of them are, then it has to be done with the formality, just like when you sign a mortgage or when you sign a deed. So when you go to closing, remember the person with the notary stamp is stamping some documents and not others. The documents that they're stamping are the ones that are going to get recorded in the real property records, right? This gets filed in the real property records. The covenant amendment has to be filed, okay? So more than likely, we're having a project where we have to get, say for example, me and my wife own a lot together. You have to get both of our signatures. I can't sign for her. If you've ever had an out-of-town spouse and y'all were buying property, do you remember having to sign a power of attorney? That gets filed with the deed when you sign for your spouse who's out of town, because that proves to the world I had the authority to sign for my spouse. Just because we're married doesn't mean I can sign on her behalf, not for real property purposes. It's the same formality with covenant amendments. I occasionally, in fact I did it this week, spoke with someone where they've asked me to give an opinion or collect dues or something like that, and the first thing I do is answer the question, are the covenants valid? I don't just jump in and, okay, here's your account statement, let's go. I have to answer the question, does this person owe this because they live in a neighborhood that has mandatory association assessments? Well, so I prepare a governing documents file. As I'm going through and preparing that file, if I come across an amendment that's signed by the president of the association, that raises a red flag. I better find something to connect that dot. And that dot connection is language in the original covenants that says covenant amendments may be adopted by the board and filed and signed by the president of the association. Dot connected. That language is never there. So what I have is an amendment that more than likely is not valid. Okay? Well, I can't rely on that. I can't enforce covenants that are not real. Okay? So we have to make sure that we're following a process and procedure that at the end of it gives us a duly adopted and properly recorded covenant amendment. So that's answering the question, who has to sign, and then also how many. Something to be careful of when you're reading your amendments clause, does it say a majority of the members of the association? Does it say the owners of a majority of the lot? Does it say members of a majority of the association? Those are all different percentages, okay? Because if it says owners of a majority of the lot, the percentage is applied against the lots, right? Majority of the lots. If it says majority of the owners of the lots, the percentage is majority of the owners. So we have to pay attention to what does the language say, because that's how we answer the question, what percentage? So who all votes? What does it look like? How many of those votes do we need? Sometimes there's a timing issue. We have a case in Oklahoma that says if your covenants say, these covenants shall run with the land for 10 years, at which time a majority of the owners may vote to amend, otherwise they continue for another 10 years. That at which time, the court says, it means exactly what it says. On that date, you get a majority vote, or the covenants extend for another 10 years, and within those restrictive periods, it's not a majority, it's unanimous, it's 100%, which means no amendment. I mean, if it says 100%, if it says 90%, we have to be really convinced we've got the votes to do that, and that's a rare occurrence. It has to be something that's a no-brainer, right? This 11 OS 42-106.1, this answers the question, not only what percentage are we looking for, but also how that percentage is applied. So if you go to OSCN and look at 106.1, what it's going to tell you is if your covenants have been on file for 10 years, then you get a vote of the owners of 60% of the lots. Excuse me, 70% of the lots. If they've been on file for 10 years, it's 70% of the lots. If the covenants have been on file for 15 years, then it goes to 60%. This is a statute that was adopted mercifully by the legislature to give us some relief when we have covenants that aren't helpful. Aren't helpful meaning they don't have an amendment clause. People actually file covenants with no amendment clause. And if they don't have an amendment clause, it takes 100% all the time, every time, to amend those covenants. I mean, it's jail. It's not going to happen. Yes, ma'am.
And my neighborhood's majority rental houses, so it would be the owners of
The owners.
rental houses?
That's correct. The owners. So if you're in a neighborhood that has 50% landlord, and the idea is we need to amend to restrict leasing, there are instances where you can get landlords to vote to amend covenants because it's in everybody's best interest. Fine schedules, surprisingly enough, we usually have good response from landlords. Leasing restrictions, no. Nope, that's
But those
gonna
figures you
fail.
mentioned only apply if there is no amendment procedure in the covenant.
They apply if there is no amendment procedure in the covenants, or if there is an amendment procedure in the covenants and they've been on file for the requisite period.
So either way.
Either way.
So that number that's in the amendment clause diminishes over time regardless of what it says within?
That's right.
It says 75%.
Right, so once the covenants have been on file for 10 years, you would go to 70%. When they've been on file for 15 years, it goes to 60%. So here's an area we can fight about. Go back to our 6 phases of development. And we've got phase 1, covenants filed 20 years ago. Phase 2, 15 years ago. 15, 10, and then 5 years ago. It's all one association. All of the covenants are verbatim. They're exactly the same. Do we get to use the 60% that we have for all of these for this one that was just filed 5 years ago? Or do we have to use a different percentage? You're going to get different answers from different lawyers. And there's a conservative answer and there's a more risky answer to that. Yes, ma'am.
So is that like 10 years, decreasing of the amount? Does that matter if you're an interim board? Because right now, for example, we're interim board, we're going to go, the HOA will be handed over to.
It's strictly conditioned on the date of filing the covenants. Has nothing to do with the association, its operation, its board. It's strictly on the date of filing the covenants. Yes, sir.
In this day and age, can voting be done electronically?
It can from a corporate standpoint, currently cannot for covenant amendment projects in terms of
Physically done?
It does. And so the thing that you need to take away from a covenant amendment project discussion is, in virtually every single case, you're going to have to go door to door and collect the physical ballots. And it's typically not just one person. We send two, one to serve as a notary, the other person to do the talking. If you want to know the secrets, I want an elderly gentleman and a younger, more attractive lady to be the two to go door to door. That's just, that combo seems to work the best.
Who does the talking? I was gonna say, it's the notary.
The next secret, it really depends on the makeup of the neighborhood. If it is a younger neighborhood with families and kids, I want the lady doing the talking.
Okay.
And if it is an older folks community, and define that however you want, then I want the gentleman doing the talking.
Properties have to be notarized?
So the way we do this, I have a piece of paper, and at the top it says ballot and proxy. This is not typically a corporate vote. It is a real estate vote, and we have to have notarized signatures. But because there is someone out there and a lawyer to join them who will argue, nope, this is invalid because there weren't proxies and you didn't hold a proper meeting, what I do is, when that person signs and we notarize, they have just issued their ballot and their proxy, and I file that in the real property records. So if we get our 60%, I mean, we don't care about quorum, we don't care about corporate procedure, but we will have hit all of that stuff if we hit our requisite percentage. So I use proxy language, not because I believe we're having a corporate meeting. It's so that I don't have to defend the fact that we didn't have a corporate meeting or we didn't have proxies or a quorum. I mean, it's the wrong argument for what we're doing, but just so that we don't have to argue it in the future, I put that language on there. Generally speaking, though, proxies do not have to be notarized. Okay, and a proxy is simply a document that says, well, we talked about proxies last week, yeah. No, they don't have to be notarized. Bylaws. Talk about bylaws real quickly. So if you go look at 18 OS 1013, what it's going to say is, it's got some confusing language about, well, before the stock is issued and then after the stock is issued, forget all that. Buried down there, it says, and the nonprofit bylaws may be adopted and amended by the governing body. If you go to a different section of law, you're going to discover governing body is defined as the board of the association. So all of that's to say, under Oklahoma law, your board unilaterally can amend bylaws, except if you are a condominium association. More than likely, your board cannot do that. In fact, I don't think it's fairly debatable. I don't think you can. You could probably find somebody that would say 1013 trumps it, but I don't think it does. The other exception would be if your board is planning on doing something that is a hot button issue that you think is fairly incendiary, then submit it to a vote of the membership. Don't do something just because you can. There's all sorts of things that I can do. It doesn't mean it's advisable. So if the board is contemplating deleting the due process section out of your bylaws, don't do that yourself. Anytime you're taking what is actually or perceived as taking away rights, submit that to a vote of the membership. Get them to pass that and clear that. That way it's not on the board. If you are adding rights, if you're changing the annual meeting date from the first Monday of every December, which is unnecessarily restrictive, to when the board determines, but no less than once a year and in the fourth quarter, great. Then change that, okay, and keep doing business as you probably have been. Okay, so that's the thing with bylaw amendments. Last thing I'll talk about is think in terms of building in yes votes and getting your vote. One of the things that I ask or that I want to see from an association before we head down an amendment project is what is your collections rate? You know, if you have a 70% percentage to hit and your collections rate is at 50%, that's a pretty good indication to me that you don't have a whole lot of people that are too jazzed about funding your association. What makes us think they're going to be super thrilled to vote on this? So we usually look for collections percentages around 90, 95%, something like that. What is the indicia that we are going off of to indicate this is going to be a successful project? Do we have a straw poll? And this is where online surveys are really good. Facebook can actually be used. Nextdoor can be used to take straw polls. Hey, we're thinking about amending the covenants. This is the thing that we would like to address. Would you be in favor of it? Yes, you get 90% response. Great, that's a good indication this is going to be a successful project. Okay. The voting ballot also building in yes votes. So if we want to adopt a certain covenant that, say we want to adopt a leasing restriction, a fine schedule, and no basketball goals. Okay, we want to combine those three amendments into one project. I would suggest that you do a line item because those three are not mutually exclusive. We can adopt one and it doesn't harm not adopting the others, okay? And it's entirely possible, I am all for leasing and fines, but you take away my kid's basketball goal and I'm going to fight you. Well, if you make it an all or nothing, I'm a no vote. Okay, so you can build in yes votes, at least for some of the project, and get a couple of yeses, but not sacrifice the whole project. So that's something to consider. You know, depending on the specifics of your project, do you want to do an all or nothing? Now, if we're doing a consolidation project, if we're going through and removing all the developer language, it's got to be an all or nothing. Okay, you can't draft okay, we're going to take the developer provision out here, but we're not here. You end up with a Frankenstein. Let's talk about insurance for just a second, and we got a few minutes left. So the main thing I want you to remember on insurance, particularly if you're a condominium association, the policy has to match the governing documents. If your governing documents as a condo requires your association to repair, maintain, and insure from the gyp board, which is the material that is under this paint, your policy has to cover that, okay? And there are different types of policies. If that's all your association documents require the association to insure, something called a blanket policy is going to be too much. A blanket policy is not just the gyp board, but it's the finishes as well. Okay? It's too much insurance. We're still in a market where insurance agents have no idea how to place condo policies. Goodness. We'll get there, but it may be that your condo association's paying too much or finds out at the very worst time that you don't have enough insurance. That's primarily a condo problem. Homeowner associations, not so much, okay? The danger area in homeowner association, and this affects condo associations as well, is if you've got a nice brick perimeter wall and you've got a clubhouse in the middle with a swimming pool, if the association gets a liability and a casualty policy, it may not cover that brick wall. So I plow my truck through it one night, you know, the gate won't open fast enough, so I plow through it. Your insurance may or may not cover it. That's a question to ask your broker or your insurance agent, okay? Directors and officers insurance, I'm going to couple this with employee dishonesty or embezzlement. It is happening more and more. This isn't one of those things where it used to be underreported and now we're hearing more about it because people are talking about it more. It is not that. People are stealing money more and more from homeowners associations. And you don't want to find out that the money is gone when you need it, okay? So we did an embezzlement class. We'll probably do it again this next summer. And Pat, by the way, Christy, Patrick did a fantastic job. I don't know if you saw a video or something, but he did a great job. So one of the things that you can do to protect yourself against embezzlement, apart from having regular board meetings and looking at reconciled bank statements, those are really good anti-theft protections, is having insurance that covers in the event that there is money gone, all right? And so this is employee theft, this is, there's a range of it. And so talking to your insurance agent, whether it's a bond, whether it's an insurance policy, whether it's your in-house bookkeeper, outside manager, whoever has access to that money either needs to be bonded or insured, okay, to cover that amount.
Talk about social engineering coverage.
Social engineering coverage?
So, the internet's a great thing, right? And we have Facebook pages or LinkedIn pages, or maybe somebody in your family does, whatever that is. Social engineering, pretend to be somebody else to get you to move money. It's different than data theft or cyber theft. Data breaches, different than that. It's a specific coverage to get you to authorize wire money or sending money or sending somebody at the bank on your behalf. How they get into your system is that they find out who you are, they send you an email, they watch you for a while, they get a keylogger on there, they watch you for a while. They'll send an email to somebody you're used to sending emails to, and they'll say, hey, I'm in a meeting right now, but I need you to call the bank or send an email to the bank and wire this money. And they sound like they're you, but they're not. And so this happened to one of our clients, and it's a family business, and the dad emailed the son and said, hey, I need you to email money. I'm in a meeting right now, so don't bother me, don't call me. And he was just in the next office. He said, this is fishy. Somebody had gotten into their system. So it's more than just the guy in Nigeria that tells you to send money. They pretend to be you. So there's insurance coverage for that. One of our clients, actually in the Carolinas, is a management company that had the coverage, and it saved them about $100,000. So it's significant. Think about that as when you start asking those questions about insurance, because you're volunteers, you have emails, you may have your personal email, you may have treasurer at Happy Hills Homeowners Association. There's a whole lot more information on that goes with this insurance package.
Yeah, and I think you mentioned that the different slivers of not just embezzlement, employee theft, but ransom insurance, where I come in, I need to pay the bills, and we're locked out, and all my information is locked up, and I have the communication. I'll release it for X number of dollars. There is insurance to cover those instances as well. There was a law firm in Houston that had a client deposit. It's very common to take retainer amounts to fund client bills for a period of time and then replenish it. They took a very large retainer. A couple days later, client decided, turns out don't need the work. Please refund my retainer, which they did with good money after fake money. And they found out after they had issued the refund that the check that they had deposited was a fraud, fake. And so there's, there's insurance to cover those instances. So what the problem is if, typically back in the embezzlement scenario, when you find out that that money is gone, particularly if it's there's two ways to steal money. There's, you kick in the door and you run yelling. It's all gone. Everything that they can get their hands on, it's all gone at once. That's really the instance where if the manager, employee, whatever, takes off with the money, how are you going to operate? How are you going to pay the pool people? How are you going to keep the facilities running? If someone's slowly skimming over time, it may be that you're looking for a recovery of a large amount, but it's not so much of an operations crisis. Okay, so all of that's to say, it's not to try to scare you and the sky is falling, but just ask knowing those questions to ask and the coverages to try to put in place. Yes, sir.
Talk about insurance that wouldn't have been toying with the idea of an audit. But audits seem to be very expensive.
They are.
Something we should be considering anyway.
I wouldn't use the term audit, an annual review. The very best, in my opinion, and this is debatable, but the very best anti-fraud detection device is regular board members who look at the financials and understand what they're looking at. It's very difficult to dummy up a bank statement and a reconciliation statement. And having different sets of eyes and particularly different people who write the checks and prepare the reconciliations, it's very difficult to steal in that instance. Okay. Let's talk about a couple things. I know we're kind of over, but I think I talked a little bit too long on collections. There are a couple of things that as a board member you need to tune your eyes to. And one of the things, if you are a new board member, what you should do is look for resources that are available. Community Associations Research Foundation, CAIRF.org, is one. They have some best practices reports that are available. You can download, they're in PDF. They have one on reserves. They have some on board operations. Where's some of the other ones they have? Developer transition.
Yeah, they have quite a library.
Yeah, and they're free. They have case study. They're really well done. CAIRF. If you do a search for CAI best practices, that'll probably get you there. But CAIRF.org takes you directly to their website. Anytime you come across the word shall in covenants or statute, it means mandatory. You have to do it. You can't delegate. So anytime you see shall in your covenants, you want to pay attention. Will, may, can, those are permissive and discretionary, but the shalls we really pay attention to. It could be its own, in fact, we should probably do another one in addition to embezzlement, but just a board member primer on how to be a good board member. But the basics of being a good board member, there are some high points. One, read the covenants. And it's not that you have to know them inside and out, be able to quote chapter and verse. It's you have to know at least what questions to ask and where to try to get the answers. You can ask me as a lawyer what the law says on something, and I may or may not know it. The idea of being a good lawyer isn't I have all of it at the instant command in my head. I just need to know where to find the answer. Okay. That's the same thing for board members and your role as leading the association. So, well, I don't know the answer off the top of my head, but I think it's in the covenants, and so let's go here and look. And find a mentor. There's nothing wrong with finding someone that's walked that road before and picking their brain. That's exactly what I did when I became a lawyer. That's what you can do and I'm sure some of you have done that in other aspects. My dad wasn't a cattleman, and so when I wanted to run cattle, I latched myself onto a guy that knew what he was doing, and so now we run cattle. It's the same thing as board member. Find a good mentor. Another high point, I've already stressed, meeting regularly, looking at the financials. Under Oklahoma law, filing the Form 1120H at the federal level, got to do it every year. That brings in really good immunities. Also, the business judgment rule says you don't have to be right 100% of the time, because in board member participation or operation, just like virtually every other area of life, there are often multiple right answers. And what we're not going to do is hold our board members to a standard of, okay, you're liable personally or the association's liable anytime somebody disagrees with a decision you make. Because that's going to be all the time. You will find somebody that disagrees with your decisions. So we're not going to create a situation where you're personally liable. That's the business judgment rule. As long as you have made a reasonable investigation into the facts, definitely if you have relied on professionals. The lawyer said we could do this. The accountant said we could take that deduction. Okay? Now, I'm not talking about IRS and them. I'm talking about individual board or individual members suing the board and saying, you know, you got it wrong, so therefore you're responsible. The business judgment rule says they are tasked with, the board is tasked with making those decisions. We're not going to hold them personally liable. Okay? These statutes that I quote here are where we find that in Oklahoma law. The 18 OS 865 through 867, that's that 1120H filing requirement. That's section 865. 866 says, if you do that, what we're going to do is get rid of joint and several liability. Means if we're on a board together and you do something wrong, I'm not automatically responsible. I'm only going to be responsible for my own wrongdoing. And by the way, 867 says, it's not just my simple negligence. You're going to have to find that I intentionally did something wrong, something criminal, or I'm grossly negligent, where you have to be out of your mind to think that behavior or that decision is okay. It's a very high standard. It's not simply, whoops, I screwed up. It's not simple negligence. It's not like car wreck negligence. It's, I see you, I don't like you, I'm running over you. Or I'm drunk and get in my car. That's not simple negligence. Everybody knows you don't drink and drive. Everybody knows you don't intentionally hit someone with your car. That's the kind of level of liability we're talking about that you get when you file an 1120H. Okay? Really good standard of protection. Okay, I'm going to end it there. I'll send you the slides. Like I said, probably sometime next year we'll do the embezzlement class again. And thank you guys for coming 2 nights.
Thank you.
Mm-hmm.